This is Estate Planning Awareness Week. You may know that our country, our government put this week in place a few years back, some time ago, to make sure that people were becoming more and more aware of the importance of estate planning. It's a broad topic. It covers practically everything that goes on in our lives in one way or another. And we are the National Bar Association. We have come together. The National Bar is a dynamic organization that's been in place for decades and decades and decades. The largest African-American lawyer organization in the country. And it's a great organization. And our section, the Real Property Trust and Estate section of the National Bar Organization, has come together and we said, hey, this Estate Planning Awareness Week is out here. We are the attorneys who do this work. We want to make sure that we fulfill one of our major purposes as a section, which is to make sure the people in the communities where we are around the country, the people of our country, have this good information so that they can make the right decisions regarding estate planning. We'll cover in a little while what estate planning is in more detail. Of course, it's all things dealing with wills, trusts, powers of attorney, and just what happens with you, with your assets, with your family, in the event that you are building, protecting, in the event that you're leaving here, if you leave here or if you become incapacitated. Estate planning covers all of that, including all assets that you own. So what we're going to be doing today is we're going to be sharing some information as we kick this Estate Planning Awareness Week off. Today's session is all about estate planning for you and your family, dealing with real property matters, dealing with wills and trust matters. That's what today is all about. Tomorrow's event is for attorneys. We're going to be doing a continuing legal education program where we're going to be giving great tips to attorneys. CLE credit will be provided or offered. We'll be giving great information to attorneys about estate planning. Whether or not you do estate planning as an attorney, we're going to give you information that's going to help you do your practice area even better. And then Wednesday, I'm really excited. We're going to have people on who are going to be talking about building wealth in the Black community. And so, I mean, this is great. We're going to be on at 11:30 tomorrow and Wednesday. And this evening, we're coming all full circle talking about estate planning in general. I have some great guests who are here with me. The president of the NBA is going to be coming on shortly. You know, he's super busy handling all things NBA. And he'll be on in a little while to share a few words. We're going to break for a quick second when he comes on. But for now, I have some dynamic attorneys from around the country who are a part of our section, who help us just share great information and make sure that we're on the right side of estate planning and property matters. And as I said earlier, we are the Real Property Trust and Estate section. I'm Terrence Quinn. I'm the chair of the section. I'm right out of this great state of Michigan. They call it the Great Lakes State. We have not gotten snow yet, but I'm out of Michigan. I'm the president and founder of the TGQ law firm. Been practicing for a good amount of time. And I at my core, am an estate planning attorney. I don't specialize in all areas. This is my expertise. It pushes over into probate work, and it also pushes over into elder law. But at my core, I'm an estate planning attorney. As I said, I have dynamic attorneys here with me who are going to help us present tonight. I have Professor Florice Neville-Ewell, I have Jennifer Norton, and I have Tayson Gaines. I'm going to ask you all to come on in real briefly, 30 seconds or so. Just tell us who you are. Tell us why you're here this evening, and then we'll go to the next person. The professor, I'm going to start with you.
All right, I know you like saying that. I know you do, but it matters not. What matters is that we're here this evening to really celebrate what most people really don't consider, and that is making sure that they have been strategic about planning their estate. And for the last, oh my goodness, 37 years or so, I hate to say it, but it's been that long, I have been involved in property matters as an attorney. And I also teach young lawyers about it. And so this evening, I'll be sharing some basic information so that everyone, while they're en route to building wealth, will have some basics. And I'm really looking forward to it. I have been a practitioner. I'm still a practitioner, but also law professor who teaches property.
Thank you. And where are you? What state are you in?
That's a good question. I am a native, Chicagoan, but actually am with a school, Western Michigan University Cooley Law School in Michigan, but I have been dispatched to the Tampa campus. So I float between Michigan and Florida, and it's particularly nice in the winter. How's that?
All right, that's great. That's great. So we're going to come back to Florida in a second when we come to Tayson, but Jennifer Norton's another Midwesterner. Come on and just introduce yourself real briefly, Jennifer, and tell us where you are.
Yep. My name is Jennifer Norton. I'm an estate planning attorney here out of Indianapolis, Indiana. Practice just like Terrence, solely estate planning, wills, trusts, powers of attorney, a little bit of Medicaid planning. I have a law firm that I've had for the last 8 years, Norton Estate Planning, an elder law firm where we help protect your dignity and secure your legacy. And in particular, we're just preserving, protecting, and passing that generational wealth is kind of what we do.
Good stuff. Indianapolis, Indiana. All right, let's go back to Florida. We're going to go all the way down to the bottom of Florida, almost the bottom. Tayson, come on and tell us where you are. Tell us what you're doing. You're still muted right now, Tayson.
My apologies. Good evening. Thank you for having me. Tayson Gaines. I'm here in South Florida. I'm based in West Palm Beach. I also have an office in Fort Lauderdale. I primarily practice almost exclusively now, real estate litigation. So while you've heard my colleagues who do a lot of estate planning, I'm more on the real property side. So I do a lot of litigation and fighting in court that's based and surrounded in real property. I tell people that I protect people's homes and assets from greedy banks and greedy homeowners associations and condo associations and anybody else with an interest in your property. And I'm very happy to be here. I'm grateful to have all of you here. And I'm grateful to this panel of individuals that you see here for all the hard work that they put in to make this event happen. This is a very serious thing for us. And we hope to convey the messaging that we have for you over to you so you can understand why we put this together and why it's such an important issue.
Yeah, good stuff. Well, you all listen, we are the Real Property Trust and Estate section of the National Bar Association. And here's the thing, as a true estate planning attorney at my core, it's easy for me to forget about the property side of our section, which I know is terrible for me to forget that being the chair. However, I have great people here. I have the professor here and I have Tayson here, both of whom are real estate gurus, real estate experts, and they don't let me forget about it. They bring it back. And so for that reason, we're kicking this session off tonight, talking all about property. We're going to have them come on and share some details about property-related matters, information that you need to know, ideas that you should consider, and then also problems that you should be aware of so that you can work to sidestep those problems. What I'm going to do is I'm going to somewhat facilitate what they're doing. They're going to present, and then as they finish, they're going to turn it back over to me and to Jennifer, and we're going to come on and talk more specifically about estate planning related matters, giving you some tips to consider, things to consider as you're going into estate planning. Professor and Tayson, it's your show.
All right. Well, let's get underway here. Thank you very much. And again, I would just like to reiterate what Tayson said. This is just an incredibly important event. So I wanted to try and cover a lot of information very quickly. And of course, law professors are long-winded. So please pardon me, I'm going to try and move quickly. But in order to help me expedite this conversation, I've divided it into 3 parts. And basically the focal point is going to be solely on real estate. So of course, the scope of this event this week is much broader. But of course, what we know, if we look at sort of how this is put together, your estate is ultimately made up of many different assets, from savings, stocks, mutual funds, bonds, vehicles, retirement accounts, and real estate. And that's our focal point right now. According to the Washington Post, a survey in 2017 noted that only 42% of adults had estate planning documents, such as a will or a trust. In 2020, Essence and Black Enterprise reported that only 30% of African Americans had a will or estate plan in place. Those statistics explain exactly why we are here. But we might be preaching to the choir because your presence here suggests that you understand how serious this is. But toward that end, I have 3 goals. First, to identify what I call layers of real estate opportunities to establish or enhance your estates, which real estate and estate planning lawyers can help you structure. Second, to provide you with basic preliminary resources to continue your pursuit of getting your estate planning underway or in order, recognizing again that your best and ultimate resources are the very lawyers that you'll hear from later on. And finally, to encourage you to share this information you learn with family and friends so that we can reverse the raw statistics and work toward building more generational wealth. And with that having been said, let me get to the first point here as we look at and differentiate between your active real estate investments, as I'm calling them, and your passive investments. This basic dichotomy or split is basically how we all operate. On the one hand, we have as part of our first layer, ideally, we have everyone in their own home. Now that home also doubles as an investment. And I would really like for more of us to think about it that way, because that's certainly how the bank thinks about it when they lend you some money. But fundamentally, layer 1 of your involvement in this process is to have your own piece of property. Layer 2, though, is if and to the extent you decide to go beyond having your own property, is to have some investment property. What does that mean? Of course, the small investor typically owns a few units and buys them and maybe flips them, as we call it. You know, you buy some, you flip them, or you buy them and you actually rent them out. But fundamentally, what does it mean to suggest that the property or that your involvement is active? It means that particularly if you have investment property, and then in the layers 2 and 3, you are actively engaged in preserving that asset. What does that mean? That means that you're involved in every phase of the process, from acquisition to maintenance to sale. What does that mean? That means that you need to have a team around you to take care of the asset. And then, of course, to have the professional team of individuals who are involved. Now, with respect to layer 1, I want to make a note that you can either own that as an individual or you can own it jointly. And so let's pause for a moment, talk a little bit about joint ownership, because as lawyers, we really have to pay very close attention to how we set up your deeds when you buy property. So if you own it ABC individual, that's easy. But more often than not, there are 3 types of joint ownership that we want you to pay very close attention to or to be aware of. The first type is if you have a husband and wife. We call that the tenancy by the entirety. The second type is a joint tenancy. And the third type is a tenancy in common. Now, these different types of joint ownerships have very different outcomes depending upon what happens, and there are different rights that correspond to them. And so ultimately, if you decide to buy property with other people, it's important to know those distinctions. And my estate colleagues are really interested in knowing about these distinctions. Let's assume, for example, that you want to buy the property and you want to invest in it or have an investment piece of property, and you decide that you want your grandchildren to also be able to profit from the property. Well, at the end of the day, the best way to structure that might be as a tenancy in common, meaning if you decide that you have the property and then you give it to your 2 children, and if they have children, if they have a tenancy in common, once they pass, that interest is going to, if you will, go down to their grandchildren or to their children. But if you do a joint tenancy, and let's say you own the property and you deed it to your children, as tenants, as joint tenants with rights of survivorship, once one child dies, that child's children will not get the property, but rather the other child will get the property, which will mean one set of grandchildren potentially will not get any property. And so these are the types of things that we talk about when we meet with clients when they are preparing to try and make decisions about what they want to do with their property. So joint ownership is a very, very important decision to make because it can have long-term impacts on every member of the family. Now, let me shift now to layer 2, because you'll notice that I have investment property there again. More often than not, this investment property could become, shall we say, a very serious hobby. Or more importantly, you might get some good advice from a lawyer who says, if you own investment property in your own names, there's a potential concern that we have. No doubt you'll have insurance. So if there's a casualty or if there's a problem with the property and it catches on fire or something, you'll have insurance under layer 1. But if you own it through an entity, we feel a little more comfortable because that way, not only is the entity insured, but you also have, shall we say, protection from being personally liable. So what do I mean by that? Well, let's assume, heaven forbid, that you have a piece of investment property that catches on property in layer 2, and you have a limited liability company. What's a limited liability company? What's the significance of it? Well, that is an entity that basically protects you from being held liable because you wouldn't own the property, but the company would own the property. And there's some circumstances where a court will, what we call, pierce the corporate veil. But for the most part, if you own it through an entity, if there is a casualty that exceeds the amount of insurance that you have on the property, right? If you do that under layer 1, you're subject to having your personal assets at risk. On the other hand, if you own that property through a limited liability company, you have some protection. So there are reasons why when you talk to investors, there are reasons why they may have multiple limited liability companies because they have separate entities connected to properties. And so why do that? Because let's say you own 50 investment properties. If you put all of those investment properties into one LLC, as we call it, a limited liability company, if there's a casualty, all of those properties are at risk of being used to pay for whatever the casualty was. So there are countless reasons why we have all of these different, shall we say, mechanisms in place to protect you and your property. Layer 3 speaks to the small developers. I sort of separated those from investment property because small developers are another group that has sort of, shall we say, accelerated and gone beyond just the mom and pop development. Small developers are really needed because at the end of the day, they're very few in our communities. And what do? They actually help to build developments from, new subdivisions to strip malls. And so ultimately, that's an additional layer that we would love to see more people, particularly in African-American communities, develop. And then finally, the last category, and I'll be done, is the passive investment category. Now here, what are we talking about? Well, again, when we talk about active investments, we're talking about your involvement in, actually managing, identifying, managing, and running the property along with your team of professionals. But with passive investments, particularly the real estate investment trusts, you are not involved in the day-to-day management, but rather you are only involved as an investor. And ultimately, since the real estate investment trusts are, shall we say, regulated by the Security and Exchange Commission, to that extent, if that real estate investment trust is registered with the Securities and Exchange Commission, you have some protection in making sure that when you invest in companies that own property, that the return on your investment is being regulated. So the basic split again is between being actively involved or simply having, shall we say, a passive involvement. But I'm telling you, it's a lot of fun to be actively involved in real estate before you or simultaneously or in conjunction with the real estate investment trust. And so ultimately, I just wanted to encourage all of you that are participating in this to either get involved or to, shall we say, get started. Because again, if we look at home ownership rates, the African-American community is at the bottom of the list. And for so many reasons, we know that we have work to do and that there are things that we need to do to accelerate this, to expand our communities. By the same token, on the real estate investor front, only 8.3% of the folks in our communities are, really real estate investors and or, profiting substantially from this. And so at the end of the day, that's why we're here. That's why this organization is promoting this, but our group in particular, our section in particular, is committed. And so I've given you some resources here as well. Please send me an email if you'd like to get started. But ultimately, what are some of the problems that you can have as a result of this experience? And my colleague, Mr. Gaines, is going to pick up the ball from here.
Hey, Professor, that was great information. Before Tayson comes on, we have a very special guest who's come on and joined us, and I want to just pause for a second. Before I do that, I just want to give a recap of some of the things that I heard you talk about. You talked about the importance of really knowing the difference and having an understanding of the type of way in which you own property. You mentioned the three different types of property ownership, or three different types of property ownership. You mentioned the different ways of owning property, active investments, when people are either just owning property because they live there, but they're trying to build as well. You have those that you own between rental properties, investment properties, and your residence. And then you also talked about passive investments that people can get into if they don't want to be involved in the day-to-day operation of property. They can get into different passive vehicles, such as what some people call a REIT, which is real estate investment trust. Great information. Before we transition over to talking about potential problems and pitfalls of property-related matters and property ownership, I want to bring on the president of the National Bar Association. He's serving this year with our organization. He's doing a great job. We're excited that he took time. He's super busy. He took time to come on and share with us. President Carlos Moore, can you introduce yourself to us and just give us words before we move forward?
Yes, Mr. Chairman, I'm glad to be with you. I bring you greetings. As the 79th president of the National Bar Association, I'm delighted to be with you as you celebrate National Estate Planning Week. And I'm just thrilled to have tuned in while the professor was giving such a hearty presentation. It took me back to my days in first year property. And that was one of my highest grades in law school. And so I was just, I'm thrilled to be a part of this conversation for the few moments that I can be. I'm here in Washington, D.C., and we have so much business with the National Bar Association. On behalf of the people, our theme this year is Stand Up, NBA, Strong, Tenacious Advocacy for a New Deal, Uplifting Our People. We will be meeting with the Office of the Vice President tomorrow. We had a meeting with the ambassador from Liberia to the U.S. today, and we just have meetings all week. And so, but I did want to take time out to be with you to celebrate this momentous week, National Estate Planning Week. I see there will be 3 webinars, and this is just very beneficial for our members. I congratulate you on what I know will be an outstanding week. And if there's anything I can do from the Office of the President, please don't hesitate to call me throughout the course of the year. Again, well wishes, my best wishes for this week, and take care.
Thank you so much. Thank you for your time. Like I said, I know you're busy, and we're just grateful that you took time to come stop by and give words. We want to kick the week off for sure, hearing from our president. So thank you so much. Feel free to stay on. But of course, I understand you have meetings and things. So if you have to hop off, no problem at all.
All right. Thank you. Take care.
All right. Well, hey, you all just heard from our NBA president, which is exciting that he was here while he's in Washington doing work for the community. Tayson, can you come on and just give us some knowledge and some information about the problems and pitfalls that can arise when dealing with property so that we can be aware of them and kind of try to get out the way of them?
Sure, of course. Thank you. I'm going to try to share my screen here. Let me get this up. Okay. All right. So yeah, Terrence, thank you. I hope everyone can see the slide that's on the screen. I appreciate you guys having me again. I'm very gracious for all of you in attendance. It's very good to see so many people actively interested in a topic that usually is, you know, underserved and under access for our community. So happy to have you all here. I'm going to get into some of the pitfalls, so don't get too discouraged if it sounds like a bit of a horror story. We're here to kind of fix the problems and usually prevent them. So myself with the estate planning attorneys that you see here, we kind of work together to prevent the problems from happening. That's the first step. And then if we do have some bumps in the road, we fix them and correct them and try to rectify the issues so that they do not cause devastation and destruction to people and to our community. So to get started, one of the first things, one of the biggest issues, especially where my estate planning attorneys and myself, where we interlap the most, is called probate court. And probate is a situation where even if you have a plan, right, and you'll hear from the estate planning attorneys here soon about wills and trusts and things like that, but even if you have a will specifically, and a lot of times we think a will is good, and we hear so many things about making sure that we get a will and we have a plan in place. But even if you have a will, in most situations, you have to go to, your family, I should say, has to go to probate court in the event that you or someone in your family passes on. And probate court is essentially a court proceeding where the court essentially administrates how your assets will be handled and who they will go to. And as the professor said earlier, generally in our community, the number one resource and asset that we have is generally our real property. And that's your home or your investment properties. And so obviously a lot of us work very hard to pass those assets down to our family, to give them a bridge and a head start going forward, right? So they don't have as hard a time as we had generating and building wealth. And what happens, unfortunately, a lot of times, if the process is not managed appropriately, what can happen is we lose a lot of that wealth just during this probate litigation process, right? And I'll get into some of the stories, but ultimately, essentially what happens is during this process, not only are your assets passed, but also your liabilities, right? And so your mortgages, your homeowners association dues, even your medical bills, those things are still all outstanding. And the probate process is where those things are handled. And the better we plan, the better you are with getting with your estate planning attorneys and making sure that not only your plan is in place, but that your family is educated and aware as to how it should be handled, you reduce a lot of the risks that come with the probate process. And by doing that, you give your family a very, very significant chance of preserving your assets and maintaining that wealth to stay within your family, right? So unfortunately, one of the biggest issues we see with estates when assets pass, specifically real property, passes from, let's say grandma passes or my mom, and then now these assets pass to me and my siblings, let's say in a general situation. What happens is if the traditional laws, which are called intestacy laws, right, which govern situations where you don't have a will, or in cases where even when you do have a will, if the property passes, let's say, to 4 or 5 children, right? Each one of, in most jurisdictions, each one of those children or each one of those beneficiaries would be the legal term. They all have an equal ownership or would theoretically have an equal ownership interest in that property. And that's great because we don't want people fighting over properties. We don't want our children back and forth. Well, I should get half and you should only get 10%. You don't want that. So usually we split it evenly. Problem is, or the problem that arises often in my practice, is that each and every one of those beneficiaries, let's say the 5 in this case, they all have the right legally to force the sale of that property in the court. And so they can go in court separate outside of the probate process. So after you go through probate, everybody gets attorneys, attorneys take money from the process. Finally, we get the house signed over to all 5 children's name. And then my brother, my sister pops up and says, well, I want my money. And even though mom told everybody, we want this house to stay within the family, to provide a source of residency and security for the children, any one of those children can then force the sale of that property. And under most jurisdictions, nobody can stop it. They can unilaterally force that sale. And even if all 4 of the other children and everybody else in the family gets up and, you know, screams at the judge and says, this is not right, this is not what she wanted, and you see a lot of the emotions come out in these cases, right, from the family, it still can't be stopped, right? And what happens is not just can that property be sold, but being that there's so many different ownership interests, it poses a lot of risk for the family in general, even the one who's trying to sell it. And I'll get into some of the issues, but ultimately, real estate investors, people who do this every day, like the professor mentioned earlier, right? Developers, flippers, investors, they're aware of these laws. And the minute they see 5 beneficiaries taking over ownership of a property, they start to try to exploit the weak link, right? And they start trying to offer them a little money. They look at them and they say, maybe they're vulnerable, maybe they need a cash advance, and they start getting in their head and they start offering them money. And then usually at some point, the interest of the 5 or however many family members becomes bifurcated, and eventually that property is sold. And one of the worst things that happens specifically in our community is these properties are sold below market value, right? Because a lot of the times there's nobody maintaining the property, the taxes may not be current, a number of different issues can come up, but ultimately these properties are generally sold below market value. So not only are you at risk if you don't plan properly for a lot of attorneys taking fees from all of the different interested parties, the court costs, but also in the end, that property being sold, no longer within the family, and then being sold at a reduced price. And so generally, that's not what whoever our family member was that left the property, that's generally not what they wanted, right? They wanted to stay within the family, and if it is gonna get sold, at least let it be sold for what it's really worth, right? So that's one of the major issues. There's a number of national organizations that we have as attorneys participate in, but that you guys as members of our community can access and use as information sources, right? And so I've listed some of them here. I'm not going to spend a lot of time on it, but at the end of this talk, I'll be welcome to provide my information, and you can reach out to anyone on this panel and they'll be happy to provide you with different information sources that can help you and your family through this process, right? I spoke about partitions earlier. As I said, speculators, developers, they come in and they can pilfer and poke and prod and eventually get an interest in that property and totally just dispense of a lot of the value that has been built through this real property. I just had a case. It was a $350,000 home. I had 4 beneficiaries all fighting over the property. And in the end, each one of them ended up with less than $40,000 after all of the legal fees, the fights, the speculators coming in. And so when you think about it in that context, it really places an emphasis on why you want to have a plan, and then why you want to update your plans with some of these beautiful attorneys that we have here today on a continuous basis. It's not enough just to get one plan and then over 20 years, you never update it, because you could be adding assets. You can have different beneficiaries, different children added to the mix. And so you want to stay on top of these things, because all it does is reduce the risk factor of fighting within the family and destruction of the value that your family has built. All right. So I'm going to skip through the Florida partition and some of this uniform partition stuff, but I'm going to go to what I do the most of, and that is foreclosures. And so what happens a lot, a lot, you'll be surprised, is as soon as your family member passes, their property will theoretically pass to the estate. Your family then has to go into court and administrate that estate in what I spoke about earlier in probate court, so that the judge can order the title to pass. Unfortunately, going through that process, you can spend years, right? Hopefully not, the better the plan, but I've seen plenty of them go for a year, even two, some even longer, right? And what happens during that time is it's an increased likelihood that the properties are being neglected or not managed in the same way that they were previously. And so the first thing you see is your homeowners association dues start to become delinquent, right? The taxes that are due on the property become delinquent. And sometimes, as we all know, the mortgage becomes unpaid. And now you have three separate issues, all of which could cause the family to lose ownership of that property even before the probate is resolved. And so unfortunately, what I see in my practice a lot of the times is the families, they're not really familiar with the process. They fight, they reconcile, they fight again, they reconcile. Eventually they get the money to deal with the probate, because they once they figure out, okay, we're not going to get ownership of this property until we do this probate. Let's work together. Let's put the money together. Let's go into probate. They go into probate. The probate starts, but now we're a year behind on paying taxes and paying the mortgage and paying the homeowners association. And now we have the homeowners association foreclosing. You have your lender or your bank foreclosing for failure to pay the mortgage. And you have the property subject to tax deed or tax lien auctions due to the delinquency in the taxes. As I said earlier, all of those things can cause the property to then be sold to a third party through auction sometimes without the family really being aware of what's going on. Now, there are legal requirements where they have to notice you, the bank or your lender, your HOA, they have to send you a default letter. They have to send some of these things, right? But if we're talking about beneficiaries, children who are not used to managing the affairs related to this property, sometimes these things can go unseen or just neglected because we don't really understand the importance of what's coming in the mail because we haven't been dealing with this every day. And so a lot of the times, the foreclosure happens, the family doesn't have the money to defend the foreclosure, or if they do, they can't all agree to defend it together because there's conflict on the probate side. And so what ends up happening a lot of the times is, again, speculators, real estate investors, other lenders come in, manipulate the process, and either buy out the property from the beneficiaries or exploit one of their interests and then use them to push the partition. Whichever way it goes, it ends up in the family losing the home. And a lot of the times, not only are you losing the home, but you're losing a lot of the value that was built up in that home. Even if you have equity, I've seen it happen plenty of times where we go through 2 years of foreclosure defense, and all of the fees, attorney's fees, costs, interest, defaulted mortgage payments are compiling. And whereas we may have started with 100, 150,000 in equity, very quickly when you add it with the attorney's fees that you have to pay to keep this case going, the equity can be completely depleted. And so a lot of the times we get a year or 2 years into these partition and foreclosure cases, and there's really no, probate and foreclosure cases, and there's not even any much equity left. And unfortunately, the families are devastated. I can only imagine what the family member who worked so hard to build that wealth up, how, collectively, how the family takes that. And it's just demoralizing and devastating to the entire family. You can see the pain in their faces, but you can also see that generational wealth, that support system fade immediately, and now everybody has to start over. And it's very unfortunate, and it happens disproportionately in our communities, unfortunately. So what we're trying to do is not scare you, but make you aware of the issues that happen, the issues that I litigate every day, and therefore the importance of putting the best plan you can together so that you can mitigate and prevent the majority of these issues. Most of these issues can be prevented with the proper and adequate planning, right? And so just to wrap up, why are probate estates at risk for foreclosure? Again, they're at risk because the personal representative, who is the person that's appointed in your probate case to handle all of the affairs of the deceased person, they might not be aware of where your mortgage statements are, right? A lot of the times, if you haven't done a proper plan, they can call your bank and try to make payments, and the bank will say, nope, we can't take it because you're not authorized on the account. And that goes back to your estate planning. If your estate plan is good, you have the right people put on your account, they can come right in, take over the payments, pay the HOA, pay the taxes, everything's clean, and we pass everything evenly and equitably to the beneficiaries that were intended for the assets to be left to by the family member that left us those assets. And so we want to make sure, going forward, that we give you guys the most information and access to qualified professionals that we can, who can protect these assets and protect your family from the type of destruction that I see in my practice. All right. And so lastly, if you are subject and you're in the probate process, or you're in the foreclosure process, or you know someone who is, I always tell my clients, it's never too late. Never give up. No matter how bad it looks, no matter how bleak it looks, even if you didn't have a plan, even if the plan didn't go as anticipated, there are always options. In foreclosure, you can pay off a foreclosure debt up until the day that property is sold, right? Even if you got a final judgment and the judge says it's no longer your house, you lost it, there's nothing we can do. Until another owner comes in, you can always pay off that debt. And even in certain situations, I've had those foreclosure sales undone and actually work back ways so that they undo the sale, we get it back in the family's hands, and we continue to fight of preserving those assets. So just because it looks bleak, or just because you're not familiar with a particular legal process, does not mean throw in the towel and give up. Fight until the end, because these are your assets that your family worked hard and long for. So you want to do everything you can to protect and preserve. I'm going to skip the bankruptcy stuff because we're not going there. We're going to make sure that all of our families don't have that problem. And I appreciate all of you. And Terrence, I'll turn it back over to you.
Wow, man, that was some great information, Tayson. People find themselves in all of these situations that you and the professor talked about on the front end, working to build and create an estate for themselves and acquire an estate for themselves. But then sometimes you run into problems. And so all of this is timely and great information, because I'm sure everybody on here finds themselves somewhere within what we're talking about. And like this says here, it's never too late to put your plan together in a way that can create a great future for you. So what we're going to do now is we're going to transition. I'm trying to stay out of the sun. We're going to transition into talking about how to approach this estate planning. If you show up on Wednesday, you'll hear me making the case for why everybody should have an estate planning attorney in their life. We have relationships with people like the professor and like Tayson, who can help you when you run into these real estate situations. But our job as estate planning attorneys is to help you properly build, maintain, protect, and then leave your assets in the way that you want to, according to your terms, but in a way that will work very well. When we think about estate planning in general, there's just so much that goes into it. And today, what we're going to do is we're going to dig into some things that you want to consider as you're approaching an estate planning meeting and as you're looking to build out your estate plan. To get started, let me just kind of lay a little bit of a foundation before I bring Jennifer on to kind of take us through these 15 estate planning tips. I want to give you a little bit of a foundation for regarding what is estate planning in general? Like, what are we trying to accomplish when we're trying to help you put a plan in place? And I kind of have to walk you through what happens when you don't have one in place first. So whenever somebody passes without a plan in place, and keep in mind, a plan can include and should include some form of a will or trust document, something that says what happens after you're gone, but it also can include your beneficiary designations. But let's say that you pass and don't have any of that in place. Well, probate court is probably going to be involved in order to get your assets to transfer to where it's supposed to go. And Tayson mentioned a word earlier called intestacy. Every state has intestacy laws, and those laws discuss what happens when you die intestate, which means without a plan in place that directs what's supposed to happen. And in most cases, those intestacy laws are going to direct that those assets go to your spouse or your kids or whatever it would be. But if you don't have that in place, that's going to happen most likely in most states through the probate court process. Now, probate doesn't have to be as terrible as everybody says. It doesn't have to have everybody fighting and all your assets getting eaten up and all of that. However, in most cases, we have a thriving probate practice at my firm. And in most cases, that's what's going on. Even in situations, though, where people aren't fighting, which is typically what causes it to extend like that, probate has three components that people typically want to avoid: time, cost, and publicity. When we talk about time, probate court by rule, at least in Michigan, has to take 4 to 6 months. Jennifer may mention what it takes in Indiana, but around the country, it's somewhere around 4 to 6 months or something like that, probate court is going to likely take for a regular general probate case. In my experience, on average, it takes about a year. And certainly when people fight, it's going to go into more years than that in many cases. When we think about cost, that second factor, probate court has costs. There's filing fees to open the case. The collective fees to get a case started in Michigan is somewhere around $300. It's probably similar in other states, wherever you are. In addition to that, most attorneys in the areas where I am for a regular general probate case are going to charge between $2,000 and $6,000. Of course, depending on where you are in the country, that may change up or down. But in Michigan, for example, it's $2,000 to $6,000 for a regular general probate case. In addition to that, though, and by the way, when people fight, that easily goes into 5 figures, sometimes 6, maybe potentially 7 figures. But it's going to go up as people fight. And probate court kind of invites fighting. It doesn't tell you to come fight, but it notifies everybody. It's required in most jurisdictions that when you open a case, you notify everybody that they have the right to object and how to object. So it's kind of telling them to object if they have any issue. That's what probate does. Now, it's good that that's in place, because if the person opening it is doing wrong, then you want to know how to object so you can get something started. So it's in place for good reasons. But in addition to the time and cost, there's what's called publicity. And in most probate jurisdictions, probate court is completely public. So you can go down to the county where the person passed, where a probate case was opened, and you can find out, pull the file, you can find out what they owned. You can find out all about their children, including estranged children who have to at least be notified of the case. You can find out all about their debt, and you might even be able to find out what everybody got, because it's completely public. Now, television teaches us that the way to avoid probate court is by having a will created. And I didn't learn this in law school, but a will is only for probate court. So if the only thing you have in place is a will, then there's a good chance that your family is still going to go through probate court. A will is nothing more than a letter to the court that says, don't look at state intestacy laws to decide who's in charge and who gets everything. I've already written that in this document. Here's who I want in charge of the case. Used to be called executor. Now in Michigan and in many jurisdictions, it's called a personal representative. And then who gets everything when I'm gone. But you're still subject to the time, cost, and publicity of probate court with a will. That does not mean that a will is not a good thing. A will is a very good thing in many cases, because we know what you wanted to have in place. And in some cases, a will is necessary. But in a lot of cases, what people choose is a trust, because they want to do their best to ensure that they're not in probate court. Now, everybody does not need a trust, and there are attorneys who will only do trust for you because you make the most money on them. They cost a lot more than wills do, but not everybody needs that. But you do need an estate planning attorney who can help you figure out if you need that or not. The trust does what the will in many cases will not do. If it's done correctly, the trust will help you avoid probate court altogether. But that happens if 2 things happen. It's the last major thing I tell you before I bring Jennifer on. 2 things have to happen in order for your trust to work correctly. And it's not uncommon that one of these things does not happen. The first is the trust has to be built correctly, which is why it's crucial that you find an expert estate planning attorney wherever you are in the country to help you build that trust correctly. If you think of the trust as like a big bucket, the first step is to hire an expert bucket builder to build the bucket for you. But the second step is what's called trust funding, or funding your trust. Oftentimes, this is where the ball gets dropped. If you have a good attorney like a Jennifer Norton, they're going to make sure, they're going to do everything they can to make sure that you properly fund your trust. What is that? While you're live and able, you have to make sure you have properly connected your assets, those that should be connected, and your attorney help you figure that out. Properly connect your assets to that trust. The trick is when you pass, in most cases, you don't want anything left in your personal name, because if it does, it's going to go through the probate court, even if Jennifer has created the best looking trust for you in the world. You got to make sure you properly associate your stuff to that bucket. So the second you're gone, the stuff is either in the bucket or automatically paying to people outside of court, no court being involved. And in almost every case, that's the best of all situations. But what should you consider as you're going into the process of preparing a plan? Whether you need a will or a trust, you're about to meet with an attorney. What are some things that you should think about right now? Jennifer, if you come on, I'm going to have you just jump right in and start sharing these tips, and then I'll chime in with you.
Perfect. Sounds good. So like Terrence was saying, it's never too late to get started today. So what we're going to do is go over some quick 15 tips. We'll dive deeper into the topics of will and trust in later programming. It's too much to kind of cram in one. So if you find this program useful, just know that we'll be doing future ones that go a little bit more in depth for you so that you can get, a better understanding. So the thing about estate planning, no one lives forever. So there's just no reason why you shouldn't do estate planning, because it's going to affect us all. There's no real way to dodge this topic. And so here's what you really need to consider before it truly is too late. And the first tip that Terrence and I have for you guys is we want you to examine your assets. So a lot of times when people do estate planning, they are very concerned and focused on the actual legal documents, the will, the trust, the powers of attorney. But in essence, estate planning is more than just about these documents. It's also about the assets. So Terrence alluded to, when you do trust-based planning in particular, you have to coordinate all of your assets with the trust so that nothing is left in your individual name to cause a probate. 9 times out of 10, a lot of attorneys are selling you documents. And the follow-up to that, especially if it's a trust-based plan, is who's going to help me retitle these assets? Is it going to be you, or is it going to be, do I have to do this myself? Because a lot of times the attorneys will help you with the deeds, because that's usually a legal thing. But as far as like your bank accounts, you have to go into the bank. So is the attorney going to help you with that or not? And there's no real registry that we can dial up where your assets are. So oftentimes the family goes on this morbid scavenger hunt trying to figure out where you bank, where your investments are. Matter of fact, we had a client calling today. The dad told them there's a policy. Well, there are thousands of insurance companies, and there is no way to dial up where the policy they believe he has. And a lot of times people, when they're saying about when they have insurance in particular, and it's from their employer, this is a group policy. When you leave, you lose it. And so if he was speaking of, yes, I have an insurance policy, he may have been talking about the one that they received because it was independent of his employer whom he left. So essentially, when you think about your estate plan, one of the biggest things that I think is a big miss in our community is we need to make sure we know where your assets are. Where do you bank? Where are your investments? Where's your life insurance? Do you have paper stocks and paper bonds? Do you have a safe deposit box at a specific institution? We as African Americans always have little lots of lands and plots of lands that grandma and them still maybe even have their own name still is on that deed that we need to clean up, that Tayson and Florice were talking about. So making sure with deeds, you have to know the exact state and the exact county in which that property is located. And if you get more south, sometimes they don't have these good databases. You have to actually walk in to figure out the actual plat and get all that legal language in order to figure out, does your family still own this? One of the things I think your homework can be is get started, right? This is your stuff and you're leaving it for other people to manage, and they have no clue. They're already starting behind the finish line or way, at the beginning, and they'll never get to the finish line because, your organization is your organization. Terrence, do you have anything you want to add about?
Absolutely. You're right on point. We need to create a list with your plan so that those who come after you to handle assets and handle the whole plan for you after you're gone will know what's there. The hardest thing to do is find assets at that time. But the other reason we need it, and I saw a question that popped into the chat, how do you know if you need a will or a trust? we need to know all the assets that you have. As your estate planning attorneys, we have to know that. That's one of the factors that goes into us determining whether or not you need an estate, whether you need a trust or a will. How do you know if you need one or not? Because your good estate planning attorney will let you know which one you need. And until you hear that from your estate planning attorney, I don't know how else you'd find that out. But we need to know your assets. Go ahead. Tip number 2, Jennifer.
Tip number 2 is we need to leave a debt roadmap. So in addition to leaving an asset list, you want to know what your debts are, because there are certain creditors that we call super priority creditors, like government, right? So think your taxes, think your think student debt, right? So some of those lenders are super priority creditors. Mortgages are attached to the property, so you can't just get rid of that mortgage. As Tayson put in his presentation, just because a death occurs, the mortgage doesn't go away. Hence the reason why he alluded to, when you're alive, we encourage a lot of our clients to add their children or their trusted person or representative to the account, so that way they can call in and continue making payments, so that we can, till we get things all kind of sorted and figured out, when that death occurs. So it's really, really important to leave a debt roadmap too. We're not as concerned about credit card, debts, but those people too get paid, but they're usually last on the priority list, if you will. Tip number 3 was just to get your priorities straight. So I think, Terrence, this is where they were leading to with what type of planning you need. As attorneys, we try not to tell you what you need. We try to help you flesh out what are your goals. What are you trying to prioritize? Is it family? Is it legacy? Is it financial literacy? You want to be able to pass that down. Is it instituting philanthropy? And some vehicles will let you do that better than others. With wills, when your beneficiaries receive assets, it's an outright distribution, meaning they get to take that money and go do what they want. It's under their social security numbers and their bank accounts, their investment accounts. So if they have lawsuits, creditors, divorces, and illnesses, these assets are subjected to those life circumstances, but it's theirs, as opposed to a trust, what Terrence was alluding to. You can put more parameters. If you think Rockefellers, they left assets in trust for future generations, because when you do a revocable living trust, as he was setting up, everything stays under your social security number. But when the death occurs and you leave assets in trust, it gets its own EIN, similar to the LLCs Florice was talking about earlier. And so the inheritance can be insulated from a liability standpoint, is set up properly for those future generations. And then you can put those rules, those regulations, and those goals, and they can transcend from one generation to the next, because the name of the trust will follow the money. And so we're not here to tell people as counselors, should they do a will or should they do a trust, but we are here to help you flesh it out based on what your goals are. Would you agree?
And help give you great understanding of the different routes that you can take. Our job, it's your plan. And I always tell my clients, this is your plan. This is not my plan. Here's what I think you should do based on the goals you've shared, the plans, the ideas, the information, the assets, all of that. Here's what I think you should do, and here's why, but here are some other options that could work towards that same goal. And it's your job to choose which one you want. So yeah, great stuff. Tip 4.
Tip 4, this is an important one. Set a date, set a deadline, right? Estate planning always rises on the list. And then it ever so frequently gets to the top of the list. And then something immediately happens that pushes us right back to the bottom. And so it seems like we're that never ending project. And so what we encourage our clients and prospective clients to do is set a date you're going to start, whether that's just collecting your assets, getting a list of the debts, because it is a project. A lot of people wish this was a transaction. Let me go do it, sit down, get my will of trust, pat myself on the back, I'm a good human being. And as Tayson said, you need to update, you need to be revisiting. This is something that is forever going to change and evolve with your family and the legal changes that occur over your lifespan. But setting a date tends to help people get the job done, as well as if you can have an accountability partner, that deadline can seem a little bit more real. Because I don't know about you, Terrence, but about this time, people realize I didn't get it done for this year. So it tends to be September, October, November tend to be rush dates to get the plan done.
Yeah, that's right. That's right. I'm a little more aggressive aggressive than Jennifer is. She said, set a date, even if it's just to get the paperwork together. Now, I'm going to push you a little harder. Now, and one of the things I like about this, you have two different attorneys, and you're going to see later, we have a different opinion about one of these, at least one of these tips. And I think that's dynamic that we do, but we'll get to that. I'm a little more aggressive. I encourage you to set a date to get a plan in place sooner than later. And the reason is because we don't know, and I'm not trying to make anybody cry or get depressed, but none of us knows when we're going to be gone from here. And I know that's hard to just say it that strong, but I really want you to realize the urgency and the significance of this work. And once we either become incapacitated or gone, we can no longer put this stuff in place. And so whatever is the current state is what's going to happen, even if it's not what you wanted. My encouragement to you, I'm gonna go really strong.
This is you tip number 5.
Yeah, that's right. Go. Let's go right now. Tip number 5 is to go. Let's get it done. And I'm gonna give you a date. I encourage you, wherever you are in the country, do not let October end and you have not scheduled an estate planning meeting with an expert estate planning attorney. It is that serious. I do mean it as strongly as I said it. And if you need help, contact us and we can try to help find you an attorney wherever you are potentially. We probably have one that's a part of the NBA. I believe, and I'm coming back to you, Jennifer, I believe that this work that we do covers 2 of the 4 most important questions that you will ever deal with in your life. I believe it's the 3rd and 4th most important question, but they're in the top 4. And that those 2 questions are, what happens to your assets and your children if you're gone? No matter how much or how little you have in assets, what happens to it if you're gone tomorrow? And number 2, if you can no longer make decisions for yourself, suddenly, next week, you can't make decisions for yourself anymore. Who's going to make decisions for you and what decisions will they make? I can only think of 2 questions more important than that. Those are in the top 4. It is that important. And like Jennifer said, it does rise to the top of the list and it's easy to then put it on the back burner. My encouragement to you is call an estate planning attorney and schedule a meeting before October is up and then move forward with that meeting and that plan. Go ahead, Jennifer.
Yeah, because it's really important. I'll leave you and then we'll go to the next tip, which is a lot of people sit on their laurels and they think, oh, my family is prepared. If your children don't know what to do, how to do it, and how to pay for it, you're not prepared. Okay. So, it's all well and good that you write these instructions and you think that this can be carried out. That's not the way the law views those written instructions. I mean, look at, Aretha Franklin, that didn't go so well. 4 written, she's in your state, right? Michigan. So, that doesn't turn out to be a good plan, right? Just you thinking that you took it upon yourself to put it in writing. They don't know what to do, how to do it, and how to pay for it. And the answer can't be call the attorney, right? You really want to be having a little bit more in-depth instructions and communication so that they do have a plan so that the attorneys are not running the show. Once they run the show, then you got to know all bets are off. And the planning tends to be a little bit more expensive, which is one day's delay is another day's lack of progress. So again, start today. Like you said, by end of October, let's go, because it's all we're trying to avoid a uphill battle. The longer you live, the more you acquire, the bigger that ball gets, right? The closer you get to the end, that's the steeper the curve. So the younger you are, it's easier to start now. You have less. We have a lot longer life, so we can make course corrections a lot more frequently. The longer you wait, the less time you have sometimes, especially if it's like you said, if you become disabled, if there's some type of emergency. So let's make sure that you're making it a priority, and let's put it on our goals to get accomplished by the end of the year. Tip number 6 is do your due diligence. So Terrence actually just hit on this, right? You want to research your attorneys because we're not all created equally. There are sharks in the water, right? We're here to keep it plain, and we're not going to lie to you about it. You just have to research. And so there are important questions that you should be asking an estate planning attorney. How many of these prepared? I think even more important is how many of you settled? A lot of attorneys create messes that attorney Tayson and Florice and I have to clean up because it wasn't properly prepared. They thought it was just a little document. I'm gonna put a few words in here. There's ambiguity in what you mean by a term. And the next thing you know, we're in litigation trying to figure out what you really meant. So it really is important to, in quotes, it's not a bad word, shop your attorneys, right? you want to see what do they know. I do have a list of questions that we give to prospective clients that if you knew what I knew and what we knew, these are the questions you would ask an estate planning attorney before you hired one, right? You want to know, what are their fees, right? A lot of times people are very focused on front end fees and they don't ask about back end fees. What if I became disabled? So you want to make sure you understand fees, because I think that's the biggest issue when it comes to attorneys is that billable hour model tends to frighten people away. But they're in our practice, I don't know, Terrence, if you want to jump in on this, a lot of people are moving more towards flat fees, especially when it comes to the estate planning model. Not necessarily the probate model if there's a lot of drama back there, but a lot of people are moving towards flat fee, even on the probate side.
Right. Yeah, I agree with that. One other question that I think I would ask, and lawyers might get mad at me about this, but listen, this is your plan, not theirs. How were they trained to do this work?
That's a good one.
If I were hiring I tell you what, I am hiring an estate planning attorney because my parents are moving to another state. That's a question I look for. How were you trained to do this work?
That's right.
That's hopefully they were trained. If they start stuttering, and it's no, I'm not trying to hurt anybody or anything like that, but this is too crucial. This is too crucial. Somebody who knows what they're doing.
And even in another good one is if they do trust, how many of your trusts go through probate? Especially now that you know that trust shouldn't go through probate, but there are a lot of attorneys that think that's just a par for the course. And that's one of the main advantages of doing a trust-based plan is they don't go through probate because you do the retitling of the assets today and you have to keep them coordinated with that trust up until the day that you die. So there are some pretty telltale signs of a good estate planning attorney. And we're happy to share that list. Like I said, in future programming, we may go more in depth so that we can give you guys some good guidance. But again, this is just to give you a little potpourri to get started. Because what we're trying to avoid, are the form fillers. I went by it. So again, there are a lot of forms out there. You see them online, you legal zoom it, you think you're checking boxes and it's no big deal. Those can have massive ramifications if you're not thinking through the issues. And that's what we as counselors are trained to do, is play devil's advocate. We know you come in wanting it one way, but this ain't Burger King, okay? At least in our practices. So you can want it one way, but we're going to push you. We're going to push you to think beyond what you're thinking, to, come at it from a different angle, come at it from the different perspectives of the beneficiaries and how they would feel when receiving the asset in the way that you're speaking of and how you're dividing it, to make sure that as long as you're comfortable, we're fine. We can't care more about your estate plan than you, but we definitely don't want you to be in a situation where if we take off the front page and the back page of a plan, we can't tell whose plan it is. That's where we don't want to be.
That's right. Good stuff.
Tip number 7 is stay in control. Oops, sorry. Go fast. And what I mean by that is don't outsource your family. So again, hire counselors. We can't stress it enough that, we don't want you sitting in the room and you're looking at your watch trying to figure out how much more time are you going to talk to me, because the longer I sit here, the longer you're going to charge me more. So you figure out a place where you feel comfortable, right? Don't outsource your family. No one knows more about the family than you. You are the expert on your family. So what you want to do is look for those fish, because as I say, us on this panel and the members of the NBA, we are goldfish. We may look like sharks because we swim like sharks. We're of the same genre in the same sea, but there are people out there that are caring and will do a really good job for you. You just got to be disciplined and have that stick-to-itiveness to get to the person that feels right for you. Because if it doesn't feel right, I think all of us on this panel have come across situations where we wish a client would fire the attorney, and people are terrified of firing attorneys. And it's not a bad thing. If it's not a good fit, it's not a good fit. Fire them and move on, because we all can settle up the plan or administer the plan if it's a probate. Do you have anything you want to add?
No, I'm in agreement. We can go to the next point.
Okay. Tip number 8 is we want to talk about powers of attorney real quick. And Terrence, you want to go ahead and kick this off about? I know we had a kind of.
So Jennifer and I were talking about this, and this is the one where we're on different ends of this discussion, and it doesn't mean either one of us is wrong. We just have two different perspectives, and in your world, your situation may align with what Jennifer is saying, or vice versa. With powers of attorney, these are documents that I think everybody 18 and up needs to have in place, period. I don't need to know what you own. I don't need to know anything about you. If you're able to do a power of attorney because you have capacity to do so, you should have powers of attorney in place. There's at least 2. that you should have a financial power of attorney and a healthcare power of attorney. Depending on the state where you are determines the name of the document. But generally, if you mention those terms to an attorney who does this work, he or she will know what you're talking about. Now, these documents are designed for you to empower somebody to make decisions for you if you can't make decisions for yourself, handle money and property and assets for you. Hire Tayson to deal with a partition issue that's going on, something like that, right? The power of attorney is where you empower somebody to do that. The healthcare, the financial one, the healthcare power of attorney is where you give somebody the authority to make medical decisions for you when you can't do so yourself. And you can give instructions on the types of decisions that you want them to make regarding the various issues. Those documents, everyone 18 and up need to have in place. Now, Jennifer agrees with me on all of that stuff. Where we have a different perspective is on who to choose and how to choose your power of attorney. Who should that person be? So you see here, Jennifer's tip there was to always hire 2 agents. And I think that was tip number 9. I don't know if I'm
tip number 9. I thought you were about to go to dig into the past, but I'll get to tip number 9, but go ahead.
Okay, yeah, so always name 2 agents. And Jennifer, I'll let you explain that first before I give my opposing.
Yeah, so my rationale was, okay, when you're thinking about appointing, not hiring, appointing people to be your agents, one, you want to dig into the past. No one's going to treat, if they don't treat themselves well, they're not going to treat your money well, right? So don't be aspirational when it comes to who you're selecting to be the agent to run your finances, to run your health. And then always, if you see them in high stress situations, again, that will be evidence of how they will perform under pressure if they're given the opportunity to run your estate. Tip number 9 here in this picture of the money with the bag is no one ever names someone they think is going to run away with the money, right? But it does happen. And so that leads to my tip number 9 is I'm comfortable naming 2 agents. So not necessarily when it's a spouse per se, but having 2, like it's the internal checks and balances for yourself. And my standpoint is this: within 2 years of our clients getting an estate plan, we like to require a family meeting. And what this does is it puts all those other people on notice, because when you name, in my experience, if you name one person and you have multiple children, they tend to gang up on the one that you've appointed, right? He's not the boss of me. And why does he pay that much for this? And I think he's misusing mother's money. And next thing you know, they go get opposing counsel to figure out, to do an accounting, which is to run back all the numbers and show me dollar for dollar and cent for cent where the money has been used. And so naming 2 people, there's less likely of that gang up factor. But what happens is when I recommend and I'm naming 2, this is not without heavy counseling, right? I'm speaking to the families about, do these people get along? How do they work together? How do they relate to the other people that will be affected by the decisions that they make? So it's one of the preferences that I typically have, but it's not without a process designed to help usher and support this family moving forward. So in our practice, we have a maintenance program that allows me to stay with the family as they grow and then the deaths and the disabilities occur. When you're in a more transactional world, this may not be so, because as Tayson said, families evolve. Now you go ahead and tell your kind of your take on it, Terrence, when it comes to doctrine.
Clients ask me this all the time: should I have 1 or 2 agents serve at the same time? And I always tell them, so first of all, I tell them some of my recommendations are, flags are waving and this is what I really encourage you to do. Others are, this is what I think, but it's your call. On this topic, it's the latter. So in my opinion, having 2 people serve together, co-agents, what happens if they disagree? How do you break that tie? How do you resolve that conflict? In my opinion, there should be 1 person who's in charge, but then have 2 backups. I always have at least 3 people total. Person A will serve. If she can't, person B will. If he can't, person C will. Now, I'm trying to avoid that conflict and everything. I do certainly agree with Jennifer's concern about people ganging up on that 1 person. What I encourage my clients to do with that, if they take my advice or my thought and just appoint 1 person at a time, I encourage that person who's appointed whenever they serve to make sure they keep immaculate records of everything that they're doing. Maybe have the person who the client put in the document that the person they're appointing has to provide an accounting to all the other individuals. A lot of the times the issue is the other family members don't know what's going on and they're concerned that something is going on that's not right. Let's build a document to alleviate them of that concern, but still leave the ultimate decision in the hands of one person. That's typically what I do. At the end of the day, you have to decide based on your situation and your family what's best. But hearing these two ideas can help give you, the choices that you need to make.
Absolutely. Let's see. So this leads exactly what Terrence was just talking about. Tip number 10 is to communicate effectively. A lot of times people appoint people to be their agents under the power of attorney, and the person has no clue, or they may have mentioned it by the by, but they didn't take them seriously that they were really appointed. And so one of the things to reduce the drama, the missed expectations, is to make sure that we're communicating with the people that we're appointing, as well as the people that we're not appointing, because whoever you believe to be the troublemaker, you are correct. They may put on, this whole facade that they're going to agree and they're going to get, they're going to get along. No, they're not. Their true colors tend to always rise to the surface, and we have to deal with it. So rather than them blaming the attorneys and blaming us as the professionals, it's really, we try to encourage you to communicate directly with that agent, so that they know kind of what their roles are, the parameters, like Terrence was saying, making sure they know, keep your records, because if it does come back and there's an issue, we want to make sure that you're protected as the agent. Tip number 11 is to provide instructions. Terrence was also, getting on this one too, is these powers of attorney are just blanket authority to do everything under the sun. And so our goal is to help promote family harmony. And when it comes to those healthcare powers of attorney, they can sign you into a nursing home, sign you into a hospital, sign a contract to have someone come out to your house. But what we want to know as the practitioners, we want to know what decision would you have made? Could you have made it yourself? And so sometimes that requires you to go a little bit outside the document to create checklists, to create questionnaires, so that we can pull from the client, what do you mean by, I don't want to be prolonged with artificial nutrition and hydration? What if does that mean if you're in a vegetative state? Does that mean if you're, get a terminal illness and you only have a 6% chance of living? Should we make you comfortable then, or should we still be, going full force? And so these tips all lend itself to making sure that we're communicating, especially, I guess, Terrence, what would be your experience in our community when it comes to estate planning and communication?
Oh my goodness. It's everything across the board. Sometimes they communicate well. A lot of times, I've had a lot of clients coming in, they don't want to share any information. They want everything to be private. And then later on, families are trying to find documents, they're trying to figure out what to do. And it can be a bit troublesome. I agree. I think that communicating well, providing instructions, making sure things are as open as you're willing to allow them to be, is a very good move. Great points.
Tip number 12 is be intentionally careful, because money doesn't grow on trees. And I think if you've gotten anything, excuse me, from Tayson's presentation and Floris's presentation, is a lot of our money is tied up in our real estate. And if we're not careful about how we own those properties, how we intend for them to transfer at a death, when Floris was talking about joint ownership versus tenants in common, et cetera, and how it will pass if you don't have a plan, or how the default law works under real estate, then we can lose a lot of money, and a lot of that generational wealth that we're talking about can be lost. Hence the reason when Terrence was going into wills versus trusts. So wills, those outright distributions, if you have people that are special needs, if you have people that have dependency issues, maybe will-based planning is not the vehicle for you. Maybe you need to be really exploring trust-based planning so that they don't get disqualified from those governmental benefits they qualify for. Maybe we need other people to run their money. Maybe we need to put the brakes on how the wealth transfers from one generation to the next. Because this is a prime opportunity. A lot of times what we find is you may be the generation that has the wealth right now, or your parents do, but you don't even know if they have a plan. So let's be very intentional about money, and let's go ahead and have those conversations like Terrence was saying, because we're not, we want to keep it close to the chest, but that tends to be more harmful than it is helpful.
Agreed.
Tip number 13, you want to take this, Terrence, about engaging the family?
Yeah, so one of the things that Jennifer and I both do, and I think any good estate planning attorney will do, is they encourage or require their clients to engage in a family meeting about the assets. So first of all, it'd be good for you to talk to your family I'm sorry, not about the assets, but about the estate plan. Of course, it'd be good for you to talk to your family about that. But one of the things that we will do is we will have a family meeting wherein we'll meet with everybody together and we'll discuss your estate plan with the family. There are all kind of benefits of this. And of course, we discuss as much or as little as you want. If you don't want them knowing your assets, we don't talk about the assets. However, in many cases, it's best for them to know who's in charge if you become incapacitated, who handles money, who makes medical decisions. What's your choice regarding receiving life support? You know, what's going to happen when you're gone? Who handles the money then? What's going to happen during that? One of the benefits of that is sometimes families are going to fight over the different assets and everything after you're gone. And if they heard in the meeting what you wanted to have happen, that helps us if we serve the family later on in court. If a court case happens, we can certainly bring that up, that you were very well aware of what dad wanted. You were in the meeting and said that. The other benefit is if you become incapacitated or something like that. I've had clients who went on and went after guardianship and conservatorship for a client, ended up getting suspended because they didn't do it correctly. And then they hired me. They became a client after that, only for me to then find out they never had to go for conservatorship because they were a joint owner on the account or some arrangement like that. And then they would ask me with tears in their eyes, well, can we stop this? And the answer is no. Once you get that ball rolling, you got to keep on going. Had we had a family meeting earlier on, and I said to them specifically, listen, if anything happens to dad, don't let anybody talk you into guardianship or conservatorship. Call me immediately. These documents that are in place should avoid that, should help you avoid that. That family meeting is crucial. And you definitely want a good estate planning attorney helping you through that meeting.
Yep. And don't be afraid to include your financial advisor. So if you guys are working with financial advisors, they're good to know because then they know who from the family is going to be contacting them. So Terrence and I both are welcome relationships with your financial advisors and your CPAs. So that way, especially if you're disabled, we can have continuity in your plan. We don't want to go hire new people. We want to use your people.
That's right. We have 2 tips in about 2 minutes. Let's do it. Let's do it.
There we go. So tip number 14, we kind of already touched on this. Is just making sure you understand the fees. Okay. There are 3 fees to an estate plan. There's what will you charge us for it? We always get that question. That is the document. What if you become disabled? And what will you charge my family after a death? Tayson hit on this. And so understanding these fees, and a lot of attorneys will tell you it depends. If you've gathered your assets, and you know what you have, the hypothetical when the attorney says it depends on what you own, and they're not going to know what you own at your death. So by gathering your assets today, you can toss one back at us. I have a hypothetical myself. What if I died tomorrow and these are the assets that I own? Now, any experienced attorney can look at the complexity of the assets that you own and kind of give you a ballpark figure. But like Terrence said, you're looking somewhere between 2 to 6 is where you're at. If you're organized, it could be even less than that, you know, on the lower end of that spectrum. But making sure you understand the fees, because every cent counts in a death, right? A lot of times the beneficiaries are there just to say, hey, just leave me something on the table. And that's not really what you want, right? Beneficiaries do want the maximum amount of the inheritance that you are intended to leave to them. And then I guess the last tip, and then we'll open up for a quick, and we'll look at the chats with some questions, is tip number 15 is think about your legacy. A lot of times people think that estate planning is just about passing financial wealth. You can also pass your legacy, whether, especially single people with no children. I find that they struggle a lot with this, don't you, Terrence, when they're trying to figure out, well, who should I leave it to? Do you often have these conversations about legacy and what that means to them?
Absolutely. You want to talk through all of that. And remember, what we're doing is planning around those 2 questions in a way that will impact generations. And so you want a lot of thought to go into this, and you want somebody by your side who's probably seen most scenarios to help you think through these kinds of things. So yeah, arranging that estate, you know, having that conversation with yourself about legacy is huge. I love this list here.
Yeah. So this is our kind of final list. Examine your assets, leave a debt roadmap, get your priorities straight, set a date and deadline. Terrence says start now. You got till the end of October Do your due diligence on the attorneys. We want you to stay in control, right? Making sure you're digging into the past of the people that you're naming. Figure out how many agents you want to name. Again, with the counsel of your attorney, you can pick the right number that makes sense. But make sure you're always communicating effectively, whether that's directly to the agent or providing those instructions to the family so that they can have smooth transitions during those life events. Be intentionally careful about the money, making sure that we're creating estate planning vehicles that will get the money to do what your goal is. And tip number 13, of course, engage the family, understand all the fees, and arrange your estate so that you're leaving a legacy that that you can be proud of. And this is my favorite slide in all my presentations. We can always lead a horse to water, when we have these conversations. We just can't make you drink. Okay, so hopefully you can take some of these tips that we've provided to you so that you can get started on your estate plan. We hope that you watch out and like, share, and all that stuff with the National Bar Association, so that when the real property and probate section, when we host other events where we're going to delve deeper into these topics, that you can, participate and get some more of that in-depth training. And now I'm going to turn it over to Terrence so we can answer some questions in the chat. I think we got a few.
Yeah, this has been great information today from Professor Flores, from Tayson, from you. This has been dynamic today. I'm excited, and we planned it. Anyway, we got like a minute to answer these questions, so I'm going to rapid fire them. There's one in the Q&A about deeds, whether or not a deed will specifically state if two owners are joint tenants or tenants in common. Tayson and Professor, I'm gonna have you all answer that one. But while you're unmuting, I'm going to answer one here that should be quick. Someone dies with a ton of debt, but no money or property left. Will a probate still be opened by debtors? If not, what happens to the debt? And the answer is, if there's no assets, then, if they can open it if they want to, but they won't get anything. So nobody else in the family should have to pay for that debt unless they previously agreed to pay for it by signing as a guarantor or something like that, which is something I never do. So again, if there's no debt, if there are no assets in the estate, then that debt is just going to be gone. There should be no estate opened at all. Professor,
yes,
answer to the deed question about whether or not it will state whether two owners are joint tenants or tenants in common.
Absolutely. In the classic deed, if one person owns the entire fee simple, as we call it, or the property, they can deed out from themselves to two individuals, and that deed must be clear about whether or not it's a tenancy in common or a joint tenancy with survivorship rights. By the same token, if you get married, the tenancy by the entirety. Ladies, men, make sure that it specifies that you're married, and that tenancy by the entireties will designate that you own the property as a married couple. You must be married in order to own the property.
Great.
That way.
Great. I've been answering many of these questions already, typing them. One other question, Jennifer, I'm gonna throw this to you. In an era of COVID, people dying unexpectedly, what best practices do you recommend regarding asset management, leaving a roadmap?
A lot of times, families can use pen and paper. It doesn't hurt. But during COVID, I guess I'm trying to get at what your question is. I think it might be from the sharing's perspective. How do you share and exchange that information? There are a lot of services out there like LastPass, right, that can log you into accounts if you haven't created an actual sheet. My preference is you create a spreadsheet. So in our practice, we take our clients' assets and we put them in a spreadsheet, and then we kind of update them. It's prettier than a spreadsheet, of course, but when you're doing the down and dirty, get an Excel. It's so easy to amend and change and copy. The amounts aren't as dire unless you feel like you have significant debts and you want specific assets to pay those off. But if you just, there's no fancy way of doing it. I do have a personal information form that I can share that helps you to start to list the things that you want to know is the account, the company, the account number, and then if you think you've put a beneficiary or you don't think go check to see and ensure whether or not you put a primary beneficiary, and you should always have a contingent. So go pull those documents. So in our practice, we have a lot of our clients, we go have them actually pull the actual statement from the institution and put it with their plan. So that way, again, the number's there, the contact information is there, we can see the account number, and we can see who we need to call when a death occurs. And if you want to update and you're revisiting, you'll see the current latest beneficiary on file, so that when one pisses you off, it's really easy to go thumb through your statements to see where their name is, and you can go switch those accounts appropriately, especially if there's a divorce, right? Just don't assume you need to go touch all of those assets, but I always start with a spreadsheet and then contact each institution to get something that shows what beneficiary they have on file or some statement, so that way it's all together in a little binder. That's the easiest way. And then you just revisit it like you revisit your taxes, right? Around that same time you get your year-end statements, you go in your little binder and you just sub things out and move things around.
Yeah. Quick question here. Should the money left to a disabled child be put into a trust? And if so, what type of trust? My answer is yes, it should in most cases. Now, again, none of this is legal advice, so don't go saying that we told you to do that. And we have to see your situation directly. Typically, if someone comes to me, once I examine their situation, it tends to cause me to recommend that they do some form of a special needs trust. That's one way of helping the child. It's not the only way, but specialized trusts that are designed to allow the child to be provided for by your assets without negatively impacting the child's potential for governmental support. So certainly, for sure, you have, in my opinion, this is legal advice. Go see a planning attorney who can do special needs planning to at least have some questions answered with that. All right, so
there was a question about a will and 2 adult children. Can they name themselves as the personal representative? A single parent with 2 adult children dies without a will. Can the adult child who lives locally elect themselves as the personal representative without knowledge or consent of the, I got to scroll too fast, of the, probably of the other. So we got our Florida people in here.
Asking after mom passed, if me and my brother, if I decided I was just going to go be personal representative, can that happen?
Yes.
The answer is yes, it can, but no, it's not supposed to. If it happened, like, it was probably illegal if you weren't provided notice. So all heirs of the decedent, the person who died, has to be given notice that you're trying to become the personal representative. Now, if you just don't show up, then to the court hearing, or if you don't object, then they can potentially be appointed. But or if they lie and say you don't exist or don't, notify you, they can be appointed. But then if you discover that, you can go back to court and they can get in a lot of trouble. So the idea is, no, you're supposed to be involved. The other sibling is supposed to be involved in one, at least by having received notice that you were trying to do this.
What's the impact of a divorce or pending separation, hidden assets?
I mean, there are all kinds of impacts, but the divorce decree actually answers that question. Because, maybe you're still listed as a beneficiary, and if the divorce decree didn't specifically address assets and beneficiary designations, for example, and you left your ex as the beneficiary of your life insurance policy, that ex probably can keep that money, can get and keep that money. In my experience nowadays, most of the time a divorce decree is going to address beneficiary designations of life insurances and things, because hopefully you notified the court of those assets, or your spouse did. And if they didn't, then that can be an issue as well. But remember, this is dealing with divorce. Separation, if it's not a legal divorce, if it hasn't been a finalized order issued, then that spouse could still get those assets.
Will the probate court settle hospital bills using proceeds from the estate, or is the beneficiary liable?
No, beneficiary is not liable unless the beneficiary already took the assets and didn't satisfy debt that was legitimately produced in the case. So Jennifer talked a little bit earlier about priority of assets. I think Tayson or Jennifer talked about it, about who gets paid first and all. It was you, Jennifer. Mm-hmm. So government, is going to, funeral is first, cost of administration, meaning the court costs and attorney fees are second. After that, our creditors. Well, even before creditors, our survivors. And somebody asked about survivor benefits as well. So a spouse and children, there's certain elections that they can make as well that have to be paid. And then after all of that come creditors. So if after all of that, there are no assets left and those creditors don't get paid, but yeah, those creditors will have to be paid otherwise. And the beneficiaries are not on the hook for that debt unless they just agree to pay for it or had already agreed to pay the debt. If you have not agreed to pay the debt of your parents' debt in any way, then they can never come after you. And that's a great question, because oftentimes those creditors will send you a letter or they'll call you saying you got to pay it, we're going to mess up your credit. And that is not true. And you never have to pay a debt that you never agreed to pay. A house is one exception.
Can I just add a friendly amendment to that? We need to differentiate between secured creditors and unsecured. Yep. And I think Jennifer was pinpointing that by saying, the credit card bills, they're at the bottom of the list. We have a hierarchy.
That's true.
And those secured creditors, as Tayson was mentioning, those are the individuals who recorded a mortgage against that property. And just because a person dies, that mortgage doesn't just, disappear. You take that property, what we call subject to that mortgage. And so that is a debt that is secured. They let your parents or whomever put that mortgage, in play, and they have an expectation of getting paid. The credit card companies, they're at the bottom of the list. They're unsecured, right? So I think we've got to make sure people understand that distinction. There's a major distinction. That's why the tax man is at the top, the feds and the state.
That's right, which doesn't mean you don't have to pay them. If there's money left over, you got to pay them before you can distribute money out to beneficiaries if it's a legitimate debt. Having said all of this, my encouragement to clients is contact an attorney and have the attorney help walk you through when and how to pay them. Because some debt, even if whether it's secured or not, some debt may not have to be paid.
Yep. If they don't file it properly, if they just call you and just send you letters, you may not have to. You don't have to pay them at the end of the day because they know they're supposed to do certain steps.
That's right. And if they didn't do it correctly, and Tayson would even talk about this as well with his foreclosure and practice and all of that. So the point is, you got to pay debt if it's legitimate and if it's timely. However, in some cases, you may not have to, but that's not a decision you want to just make. That's a decision you want to receive in a conversation with an expert.
Yeah, you'd want to wait till the end of that publication period. Don't just pay it just because the bill comes. You just make a stack and then you take them to your attorney and they'll tell you yes or no whether you're going to pay those. There's a couple other questions. The one question is, how can we research, a good attorney? Like if attorney has allegations, you need to check your local bar. There is a, disciplinary kind of list. It's a public record, so you can see if lawyers have gotten in trouble or if they're in good standing. So if that's what you're looking for, and then just kind of, stay within your network. Attorneys know good attorneys too. So, if you have a good family law attorney and you ask them about a good estate planning attorney, odds are they'll be able to refer you to a good real estate attorney or estate planning attorney if you felt like your family law attorney was a good attorney. Now, if you felt like they were a bad attorney, I wouldn't necessarily take their advice. But it's there's no real fine art to it, right? And sometimes what will be a bad attorney for someone else may be a good attorney for you. So you just have to, again, align yourselves. And then for the real property people, there was a question about where to find real estate. Like what's a good source? So I don't even know the answer to that, but.
Yeah, I'll take that one. I was responding to it. I was trying to type a response now, but essentially, I think Professor mentioned it earlier. There's no real national, you mentioned it as well, Jennifer, there's no real registry for real property assets on a national level. So unfortunately, in my experience, you have to have some idea where the property is. You have to search within that local county and that local jurisdiction, their official records or their property appraiser, tax collector, what have you. But ultimately, those records are housed on a local jurisdiction level. And so unfortunately, there are some third-party providers that search assets, but as far as official records, those are housed within your local jurisdiction. So that emphasizes the importance of the process that Jennifer spoke about, where you sit down with your family members and you get an idea of where their assets are, where they're held, where they're located, specifically with real property, so that you're not searching any and everywhere to find those properties, find those assets.
So we got to close this out, you all. Professor, I see you want to add, somebody asked about an attorney, and do we have somebody in Boston? We absolutely do. She used to be on this board doing this with us, and she just gave me her, I'm putting in the chat, she just gave me the email address that she wants me to share. So I'm going to share that right now. I don't remember who asked that question, but I'm going to share her name right now. But there was a question here.
I was going to say, while you find that, one of the things that gets tricky about listing attorneys, certain states don't allow you to publicize, have a public list of estate planning attorneys. And if we don't have a list, maybe that's something we can explore, is figuring out which states allow, and we can maybe try and share the people that we know of in our sections. But we don't have one out there yet because we got to make sure we get all the rules. But if you just reach out to our association in general, we can put you in contact with some members to search for within your state.
Somebody just asked about the two other questions I saw were, one was about, it looks like from an attorney asking if you want to get involved in estate planning, how do you get trained in it? Well, a starting point is to join us tomorrow at 11:30 a.m. Eastern Standard Time, because we have a CLE. I saw another question about, will CLE credit be given? Tomorrow's session is CLE, and it's dedicated to attorneys. So you want to register for that. However you learned about this, go back to that same advertisement that you saw, and there should be a link there for registering for tomorrow's event. It's going to be a CLE for attorneys, all about estate planning. Now, beyond that, your state hopefully has some kind of training opportunities for you. There in Michigan here, we have a legal education institute that's dynamic, and they have a 3-year course that I require all of my attorneys who join my firm to go through, where you get a certificate in probate and estate planning stuff. Other states have similar things. But truthfully, I think you've got to have a mentor. I don't really know how you become a good or great estate planning attorney, even if you attend that 3-year course, without having a good mentor, or real estate attorney, without having a good mentor who can walk you through it. There's a question here about a New York attorney. We have 2 of them. As a matter of fact, tomorrow during our CLE, I believe it's tomorrow, right, Aquanetta? During our CLE, the vice president for sections and divisions of the National Bar is going to be greeting us like President Moore did today. And he's in New York, and he does estate planning as well. And there's 1 or 2 other attorneys in our section who are New York estate planning attorneys. So yeah. And
they can join our section, because we train each other and update each other on laws and regulations and things of that nature. So getting involved, and that's the main thing, is just getting involved with that right organizations that, you feel like you're getting substantive information from. And sometimes you just take a look and you realize it's not good, because it's hit or miss, because sometimes your state bars aren't as great. Like Indiana doesn't necessarily, certain bar associations outside of maybe the Black Bar Association do a better job of, because there's not many of us in it, so you gotta kind of dibble and dabble till you find a fit that's like, oh, I'm getting good quality stuff.
Yeah, our section is going to be, we're coming to you, Professor. Our section is going to be doing trainings for attorneys. Like right now, we're working on it, trying to roll out some trainings for attorneys. That's one of our 2 goals. We have 2 major goals in our section of the NBA. Number 1 is to provide information like this to the community on a consistent basis, so that you all are making the right decisions from a legal perspective regarding your plan. But number 2 is to make sure our attorneys are trained very well to do this work at a high level, and so that we can do it at a high level to serve purpose number 1. So yes, join our section, join the NBA, join our section, stay tuned. Everybody on here, be on the lookout. We're going to have a lot of information coming, and I've talked too much. Go ahead, Professor.
I just had one quick thing. I didn't see the question about wanting to search for your property, but everybody needs to know about title insurance companies. Because on the one hand, you can go into the county where the property is located and do a search by looking in the grantor index or the grantee index. On the other hand, if you need some quick information to cover one of those layers that I talked about, you can order from a title insurance company by giving them the name and the address associated with the property so that you can get started in trying to identify all the liens and everything that are listed against, that have been recorded against that property. So those searches can be done. Now they charge you for it, but that's a way to expedite getting information about property.
You all, I think we are done. I know that, I mean, we
Thank
can go
you all. Thank you to our wonderful chair. I appreciate it. This was wonderful.
Thank
And
you all.
the PowerPoint, I think Aquanetta said it will be posted on our page.
Yeah, on the NBA website under webinar. So if you go to nationalbar.org, yeah, you should see under webinars, you should, in the coming days, you should be able to see this webinar recorded. Now listen, stay tuned for us, you all. However you saw this, there will be more things coming throughout the rest of the year. I know there are more questions. We could go on and on for hours about this. We got 4 attorneys on here talking. I mean, come on, we can go all night, you know, but we're not doing it. You know? I got a red eye I have to catch tonight. But anyway, stay tuned. We got a lot coming out, and just look for our events, and we'll be sharing a lot of good information. So with that, I want to say thank you to our NBA for helping us put this on, you know, our section put this on. Thank you to Aquanetta Betts, who's on here and hasn't spoken at all. She answered some questions, but she is the chair. There she is. She's the chair of the Estate Planning Awareness Week Subcommittee, and she is doing a dynamic job. Just say hi real quick, Aquanetta, so they can hear from you.
Hello, everyone.
Where are you located, Aquanetta?
I'm in Maryland, right outside of Baltimore.
Yeah.
And thank you all so much for joining us. It's been wonderful. All the questions, I wish we had more time. The questions are just coming in constantly. So that means we'll have to follow up and do something more.
Yeah, that's right. Aquanetta has done a dynamic job coordinating this, and she'll be presenting tomorrow with Amy Griffin, who's out of the DMV area tomorrow doing the CLE for the attorneys, and I can't wait to see it because it's just going to be wonderful, and I'm moderating the thing. But we have more stuff coming in. And of course, everybody remember that Wednesday is going to be all about building wealth, building Black wealth. It's going to be fantastic. You'll see some faces who are here, some from tomorrow, and it'll just be great. So join us tomorrow at 11:30. Be sure to register. Join us on Wednesday at 11:30. And this will just be great. So Tyson Gaines out of Southern Florida, thank you so much. Fantastic job. Professor Flores out of Michigan and Florida, thank you so much. Fantastic job. Jennifer Norton out of Indianapolis, thank you. Fantastic job. I'm thrilled that we're doing this, and this was just great. So we'll be back, everybody. Thank you for your time.